Thank you for the opportunity to share some reflections on the importance of liability risk management as a key element of legal preparedness for future global health emergencies. I just say I learned about this issue firsthand from firsthand experience. During the early days of the Obama administration, I was asked to take the lead of what is now the Office of Global Affairs at HHS, Department of Health and Human Services, and to work closely with WHO's leadership and other global partners in responding to that pandemic. What I didn't expect, to be candid at that time, was how much time and energy I spent along with so many public health colleagues in the United States and in other countries in addressing liability and legal issues in the global rollout of vaccines. It seemed to me at that time, and it still does today, that these issues are better addressed in advance and not in a crisis. The cost of time for public health leaders is too high, and the risk of delay in delivering countermeasures is also too high. So, Kat, if I could ask you to put the next slide up. As Sam indicated, I'm going to attempt to do three things this morning. First, I'll try to describe the basic challenge of liability risk management that will almost certainly arise in future international health emergencies, including a brief review of several technical terms that are commonly used, and that might be hopefully useful to all of you on this call. Second, I'll suggest several reasons why at least I think it is better to act now to address liability issues before the next pandemic or similar event. And then third, I'll try to point you to some resources being developed by the Global Health Security Agenda and others that may be of use to countries and international organizations considering this matter in the INB or in other forums. So Ken, if you could go to the next slide. Let me start then with the first, which try to define the issue that we've got before us. The issue of liability is a legal challenge that will almost certainly arise in any future public health emergency, especially during a pandemic. And I should say I realize that this is an issue that raises strongly held views on all sides, and I have my own as well. But this morning, I'm going to try and present the scenario that seems, to me at least, the most likely to occur given our past experience and think about issues from that perspective. So with that, my view is that so long as private companies can be expected to play to develop or manufacture some or all of the vaccines or other countermeasures in the next pandemic or health emergency, and that seems almost certainly the case. Those companies will seek to manage liability risks related to adverse events that could be associated with their vaccines or other countermeasures they produce. As in COVID, vaccines and other health products required to address the next pandemic or another emergency will need to be developed rapidly and will likely have emergency authorization for their use for at least a period of time before receiving full licensure. Despite rigorous testing for emergency use, as with the COVID vaccines, the introduction of products at mass scale always carries some risk of rare or unforeseen events. So for some period of time while countermeasures are in use, it can be reasonably anticipated companies will be unable to secure insurance for such risks and will be reluctant to self-insure. Why does this matter? Under most countries' laws, a manufacturer of a product faces responsibility for adverse events associated with the anticipated use of its product, even in emergencies, unless alternate provisions are made in relevant statutes or legal processes. So based on experience from COVID and H1N1 and Ebola, we can reasonably anticipate that companies are highly likely to request protection from governments and international organizations to help manage the financial risk of potential legal claims related to adverse events, including the legal expenses incurred in defending those cases. So in previous emergencies, we know the negotiations between manufacturers and countries or international entities have proven complex and time-consuming for all the parties, especially in a context when time is often of the essence. This has the potential of delaying deployment of countermeasures. Now, of course, different countries are taking different approaches to this challenge, often in the context of negotiating contracts for the purchase and delivery of vaccines. Some countries, such as the United States, provide immunity to manufacturers in most circumstances and have created a no-fault compensation program, Other countries have offered indemnification to manufacturers for damages resulting from legal claims. Some, but not all, of countries offering indemnification have established some kind of no-fault or comparable system. So, and importantly, in the context of COVID, WHO took the lead in developing the first ever compensation mechanism for low-income countries, which is, again, so that it's a complicated landscape. So, and I realize a lot of this, for those of you, may sound like a lot of legalese out there. So I thought maybe I'd try to take some of the terms I just referenced and define them. So Kat, if I could ask you to move the next, thank you. Sorry for the print, but hopefully it's readable for each of you. So given this legalese, I thought maybe we could walk through some of the key terms, at least as I see it. First is liability risk management. This is the process of managing the risk of parties being held responsible for certain types of losses. In this case, we are focusing on financial losses rendered by legal judgments associated with adverse events to countermeasures, such as vaccines. In a health emergency, this typically involves allocating risk between the manufacturers and governments procuring such countermeasures from those manufacturers. The second concept I want to talk about is immunity. Some countries, as I noted, protect manufacturers from financial risk associated with adverse events during health emergencies by providing immunity in legal proceedings in almost all cases. With immunity, the companies may move to dismiss claims brought against them without ever having to go to trial or have any significant proceedings on the facts. This reduces the company's exposure to judgments and, of course, minimizes their legal expenses. Let me contrast that with the third concept, which is indemnification. This is a legal concept in which one party commits to compensate another party for any prospective or future loss or damage. In the context of the COVID-19 pandemic, clauses in vaccine purchase contracts establish financial indemnification, often by national governments, in this case, the indemnifying party, to cover financial losses potentially incurred by the vaccine manufacturers, in that case, the indemnified party, as a result or associated with adverse event lawsuits. And so the final concept, and this focuses less on the relationship to the manufacturer and more on individuals, is no-fault compensation. Some countries have established no-fault compensation schemes, which seek to compensate individuals who experience serious vaccine-related harm or harm related to other countermeasures without requiring those people to prove fault against any individual or entity. Proving fault can be difficult to show. Therefore, injured parties or the legal representatives do not have to prove negligence or fault by the vaccine provider or the health system or the manufacturer before receiving some compensation. These systems are typically operated through administrative processes and do not require claimants to go to court. So putting these concepts together and what I mentioned before, it's clear that many, but not all countries develop explicit strategies for liability risk management. Some countries provide immunity, others offer indemnification. Of those countries, some provide no-fault compensation or access to other types of legal remedies for individuals experiencing adverse events. Some do not. Of course, not having a strategy is a policy decision in its own right, and many countries end up addressing these issues in the context of negotiations. So I hope this gives you at least an introduction to some of the basic terms and how they interplay in the context of a pandemic. So I could ask Kat if you could move to the next slide. So I thought I'd just point out 4 reasons, at least to me, why I think it's better to address liability issues before the next public health emergency rather than in the context of it. First, this can save precious time during health emergencies. Unlike many public health decisions in the context of an emergency response, which will ultimately depend on our evolving scientific understanding of the nature of a novel or re-emerging pathogen, and/or will depend on the efficacy of potential public health interventions, virtually all the legal issues that I've identified and are predictable. And I think, and at least as a result, are at least potentially resolvable in advance, or at least some are. And so time matters. Second, a pandemic or other emergency is simply not the best time for countries to draft new laws addressing inadequacies of their public health authorities or for parties to negotiate well-crafted solutions to complex problems like liability risk management. Frankly, time spent by public health officials on liability issues during a health emergency can sometimes come at the expense of time that could be used for planning or implementing public health responses. Time spent negotiating the terms of liability risks slowing the deployment of countermeasures that may save lives. So that's the second thought. And then the third I wanted to focus on is waiting to address these issues until the next pandemic is not going to make things any easier. The complex issues will not be any simpler to resolve in the heat of a crisis. And the practical reality is that the practical reality is that the companies which produce countermeasures, the countries with which those manufacturers have contracts, and the jurisdictions within which the countermeasures are produced and stored will almost certainly have substantial leverage in addressing liability risk management in the next crisis. As a practical matter, the capability to develop and manufacture vaccines on a global scale largely, though not exclusively, sits with pharmaceutical companies. There's simply no reason to wait on these issues. And then fourth, preparing in advance to address the likely demands of manufacturers for protections against loss may help reduce the risk of inequity in a future emergency. This issue has been seen to limit access to countermeasures, particularly for lower middle income countries, and especially in contexts where they may be negotiating for health products in a competitive environment. So let me turn to the last thought. So those are the four reasons I think we should act now. And then Kat, if I could ask you to move to the next slide. And finally, I'd like to share with you some resources that may be useful in developing country-level and global solutions to liability issues, including those of you who are deeply engaged in the IMB and the Working Group on IHRs. As a starting point, we owe an enormous debt to WHO, CEPI, Gavi, UNICEF, the World Economic Forum, and others, at least in my judgment, who've continued to work tirelessly on these issues over the years and have addressed them in the variety of very high stress, high intensity contexts. In particular, I want to note the work at work again at WHO in setting up the first global no-fault compensation system as part of COVAX. And you'll hear after me from Sharmila Ramaswamy about strategies that the World Bank has taken to support countries in managing these risks. You'll hear from Dick Wilder about the innovative approaches taken by COVAX during the COVID pandemic under his exceptional leadership, and from Chanel Hall, who will tell us about the complex needs of migrants who are far too often left out of these discussions going forward. So looking ahead, in my view, the most important step is for countries and global international organizations to consider liability as part of a broader legal preparedness framework for future public health emergencies. Advanced discussions on managing the liability risk of countermeasures while maximizing equitable access can lead, at least potentially, to long-term and more balanced solutions. In this way, these solutions have a better chance of being systematically integrated into countries' legal systems and incentivizing the actions of private sector partners, all in the effort to try to save at least help as many people as possible during the context of an emergency. So in other words, the more these challenges and factors are addressed in legislation, in clauses, in countermeasure procurement contracts, and in legal preparedness plans, the more rapidly vaccines and countermeasures may be available to be distributed and administered in an equitable manner and where they're needed most. So to support this work, the Global Health Security Agenda, which is hosting today's call, brought together a group of experts in February 2022 to establish a working group on liability risk management to generate greater awareness of the issue and to lift up the importance of applying a legal preparedness approach to the liability debate and to help develop technical guidance going forward. Based on this working group's plans, GHSA will be providing guidance in the following areas. Draft legislation and comparable legislation from other countries that you can review that may be enacted to facilitate expeditious procurement of medical countermeasures. Procurement agreement contractual clauses to provide countries with a starting point in negotiations with manufacturers during an emergency and to promote consistency in contractual terms across countries. Another would be indemnity planning and budgeting materials to be used in the event that funding is required to guarantee a contractual indemnity provision. and then knowledge about no-fault compensation systems that help mitigate the risk of claims by compensating individuals who have experienced or have an experience related to adverse events. So let me summarize by closing before turning to the other exceptional speakers that you have today. Time and again, the world has encountered a series of challenges during international health emergencies in accessing medical countermeasures, in part because we've been unable to rapidly resolve recurring legal issues related to liability. The complexity and time lost in negotiating procurement agreements between countries and manufacturers during COVID-19 could have been mitigated with greater legal preparedness. It seems to me before the next emergency, it would be wise to work with and support governments and international organizations to help them be as ready as possible to address inevitable issues relating to liability. And so for those of you from governments and international institutions on the Zoom today, we welcome your participation in this process and helping find solutions